The Special Marriage Act 1954 provides, number 1, restitution of conjugal rights, section 22. Number 2, judicial separation, under section 23. Number 3, nullity of marriage, section 24 and 25. And number 4, divorce, section 27. Restitution of conjugal rights, section 22. This relief or restitution by a court decree is to preserve the marriage tie as far as possible by the intervention of court. These conditions are to be satisfied for obtaining such decree. The other spouse has withdrawn from the society of the petitioner. Respondent has no reasonable excuse for such withdrawal. The court's satisfaction as to the truth of the statements made in the petition. No legal ground exists for refusing the decree. Constitutional validity. Section 9 of the Hindu Marriage Act 1955 is a pari materia with section 22 of this act. So it would be relevant to discuss the constitutional validity of section 9, which has been challenged in T. Sarita versus T. Venkatasubaya. The Andhra Pradesh High Court held it to be violative of Article 21 of the Constitution of India. Shortly after this judgment, the Delhi High Court in Harvinder Kaur versus Harmandir Singh and the Supreme Court in Saroj Rani versus Sudarshan Kumar upheld the constitutional validity of Section 9 of the Hindu Marriage Act 1955. Judicial separation, Section 23. Under this relief, a decree of separation does not put an end to the marriage. The legal status of the husband and wife subsists and they cannot remarry. The parties are only permitted to live separately. Grounds. Either party to the marriage can present a petition for decree of judicial separation on any of these grounds as specified. Under Section 27(1), voluntary sexual intercourse, desertion for 2 years, 7 years imprisonment, cruelty, unsound mind, suffering from venereal disease, suffering from leprosy, has not been heard alive for a period of 7 years under Section 27(1)(a). Husband guilty of rape, sodomy or bestiality. Cohabitation between the parties has not been resumed for 1 year after the decree or order of maintenance passed by court under Section 18 of the Hindu Adoption and Maintenance Act 1956 or in proceeding under Section 125 of the Code of Criminal Procedure 1973, and both parties are living apart since the passing of such decree or order. On the ground of failure to comply with a decree for restitution of conjugal rights, when the court grants a decree for judicial reparation, it shall be no longer obligatory for the petitioner to cohabit with the respondent, but parties are free to resume cohabitation as the doors for reapproachment are open. Nullity of marriage, Section 24 and 25. A marriage may be valid, void or voidable. Valid marriage is constituted when all the required conditions are fulfilled. Void marriage is void ab initio, that is, right from the beginning. It has no legal status and no rights and obligations ensue from this type of marriage. A voidable marriage is a binding and valid marriage until the decree of annulment has been passed by the court.